But there could potentially be a problem if the committee wants to enforce that subpoena in court, because there you can have the issue arise. Of course, this has never actually happened. But if the committee were to try to enforce either civilly or criminally a subpoena to a member, the argument could be made on behalf of that member that the enforcement in court, that the judiciary cannot get involved in this because of the speech or debate clause.
I'm Quinta Jurecic, and this is the Lawfare podcast, January 18th, 2022. A crucial component of the story of January 6 concerns what members of Congress were doing on that day. What kinds of conversations did Republican lawmakers have with President Trump? To what extent did any lawmakers play a role in engineering the riot itself? These are some of the questions that the House Committee on January 6 is investigating. And it's seeking information directly from members of Congress, including House Minority Leader Kevin McCarthy. So far, McCarthy and other lawmakers who have received requests from the committee have vowed not to cooperate. So will the committee subpoena fellow members of the House? What obstacles might it run into if it did? And what does it say that the committee seems to be nearing taking this step? I spoke with Mike Stern, a former senior counsel to the House of Representatives, and Lawfare senior editor and Brookings senior fellow Molly Reynolds, about the questions of law and norms raised by the latest turns in the January 6 committee's investigation. It's the Lawfare podcast, January 18th. What happens when Congress investigates itself? Let's start by situating ourselves a little bit in the committee's investigation. Molly, can you tell us which members of Congress the committee's requested interviews with and information from or about so far, and how have those members responded?
Yeah, so the most notable request, I think, is the one to House Minority Leader Kevin McCarthy, just given his institutional position and the precedent I think it would set if he were to be issued a subpoena. But the committee has also requested interviews with Jim Jordan and I believe also with Scott Perry, a Republican of Pennsylvania. And then there's a broader set of members who the committee has asked telecommunications companies to preserve phone and other records about for possible review by the committee. And I think it's worth noting that while these members who the committee is requesting information from and about, this is a really important piece of their investigation, it is just one piece. So before Christmas, the committee's vice chair, Liz Cheney, said publicly that the committee had done upwards of 300 interviews at that point with various witnesses. There are, additional people who I'm sure they have requested interviews with who have yet to cooperate or have indicated they won't cooperate. So I think this is institutionally a really important part of the story, but it's certainly by no means the entire story of what the committee is up to.
And why is it that the committee is looking for information from these members? Like, how does it fit into the bigger picture of the January 6th story?
Yeah, so as I understand it, they have reason to believe, both from sort of things that we saw unfold publicly and semi-publicly before, on, and after January 6th, and then from other information that they've obtained, that members were certainly involved in conversations around the planning and execution and response to January 6th. And so I think, for example, one of the things that they are interested in learning from some members about is the degree to which they were in communication with the White House on January 6th itself, including around efforts to sort of get President Trump or other administration officials to intervene. And so that is what I see as a big part of what they're trying to do.
I think I agree with that. And I note that the letter that Chairman Thompson sent to Kevin McCarthy a couple days ago goes into some detail as to what specifically they want to get out of him. And that includes, of course, the fact that he had these conversations with the White House and with the president on January 6th, which Thompson says is relevant to determining Trump's state of mind at the time that the Capitol was being attacked. But he also identifies a number of other things, including the communications that McCarthy had with the White House and with other members later after the people had left the Capitol regarding the decision to continue to object to the electors from some certain states. There's a number of other things that Thompson goes into that he wants specifically to ask McCarthy about. And I think depending on which of these issues is at play may affect the legal questions that would have to be resolved.
Yeah, and just to add to that as well. So there's also, in some cases, the committee is seeking information from members about things that happened before January 6th itself. So in the committee's request back in December to Scott Perry, that letter was largely focused on questions around Perry's efforts to install Jeffrey Clark, or sort of his involvement in efforts to install Jeffrey Clark as the acting attorney general, which was part of the kind of broader strategy to undermine the results of the 2020 election. And so it's Mike's absolutely right that some of these pieces are about things that happened after the insurrection itself. Some of them are about things that happened during the insurrection, and some of them are also about things that happened before the insurrection itself.
So, Mike, you mentioned legal issues that these efforts might run into. It seems to me that there are a couple different buckets and ways that we could break this down. One are issues raised by investigating members of Congress that are normative but not legal. One is legal questions raised that are specific to investigating members of Congress. And then there is also the bucket of legal questions about the investigation as a whole that apply to both members and people who are outside Congress that could be raised by anyone who's subpoenaed by the committee or had information requested by the committee. So to start off, can you explain what the normative objections might be here by, McCarthy, Scott Perry, Jim Jordan to these kinds of informational requests and subpoenas if it comes to that?
I think a lot of the objections would probably point out that if you go down this road, you are really opening up a new territory for congressional investigations that would have detrimental impact on the way that the institution functions. So it's certainly not unheard of for Congress to subpoena, or either house to subpoena, a member of its own house, but that almost always occurs in the context of a disciplinary investigation of that particular member. It does not generally, and perhaps has never occurred, in the context of a general legislative investigation. So if you take, for example, the questions that the committee wants to propound to Mr. McCarthy about why was he objecting to the electors from certain states. If that were considered, and this would be the argument that would be made on his behalf, if that were considered a proper topic for a committee to probe as part of its legislative investigation, you could imagine any committee starting to subpoena members to find out why they took a particular legislative position, or what interest groups had perhaps they had talked to in connection with their position. And that would simply be a major change in the way that the House operates.
Just one thing to add is I completely agree with Mike about a potential concern about precedent setting here. And I think some of this comes from comments that McCarthy has made in other contexts about how, for example, a Republican majority in 2023 would seek to remove Democrats like Ilhan Omar, Adam Schiff, Eric Swalwell from committees because Democrats sought to remove several Republicans from strip them of their committee assignments in this Congress. And so I think that sort of notion of a tit for tat there is evidence that we might actually see something like that happen.
And what is the significance of how these kinds of investigations have historically been part of disciplinary proceedings or ethics investigations? And what does it mean to you that they're now branching out beyond that? Is that sort of more significant as a step? Like, what does it mean that they've previously kind of been cabined to the ethics space?
Well, I wouldn't really say that they've been cabin to the ethics space. I just think that is the context in which the need to get testimony from members has come up. I can't think of an investigation which was sort of a broader type of investigation in which members were key fact witnesses. Like, I think this is just a unique situation or a very unusual situation. But I think the argument would be made on behalf of the members that just because you can subpoena us in a disciplinary proceeding does not necessarily mean that same power should be assumed in a legislative proceeding. So I don't think there's much of an argument that the House lacks the power to subpoena its own members for legislative purposes, but an argument could be made based on practice and tradition that when the issue of member subpoenas is likely to occur in the ethics process, the House has been very careful to set out the procedures that will be required before that process can go forward. So the ethics committee has a whole bunch of rules about when they can start an investigation, and the ethics committee is evenly balanced between majority and minority precisely to prevent one party or the other from using the process in an unfair political manner. The argument then would be made, if the House wants to allow a different committee besides the ethics committee to exercise this very serious power, it should do so and would do so only in a very explicit and careful way. And because the January 6th committee was not explicitly given any authority to subpoena members, it shouldn't be assumed to have that authority.
So let's then talk about the other specific legal issues that come up or could come up in requesting information or subpoenaing other members of Congress. Mike, the first one that comes to my mind is the speech and debate clause. Can you talk through that a little bit?
Yes. So the speech or debate clause basically protects members of the House and Senate from being required to answer questions about matters within what's called the legislative sphere. But it applies in the language of the Constitution to their being questioned in any other place. And any other place in this context means any place outside of the body in which they serve. So the speech or debate clause does not directly apply to a congressional subpoena to its own members, which is why speech or debate is not raised, for example, in ethics proceedings. So there's no direct speech or debate problem with the committee issuing a subpoena to McCarthy or Jordan or someone like that. But there could potentially be a problem if the committee wants to enforce that subpoena in court, because there you can have the issue arise. Of course, this has never actually happened. So, but if the committee were to try to enforce either civilly or criminally a subpoena to a member, the argument could be made on behalf of that member that the enforcement in court, that the judiciary cannot get involved in this because of the speech or debate clause.
Right. And we know, Mike, from sort of having watched a whole series of fights over subpoena enforcement in the context of the January 6th investigation and in other recent congressional investigations, that having to go to court, either using civil proceedings or the criminal contempt statute, has become quite common in high-profile congressional subpoena cases. And so I think that I'm just sort of underlying the fact that, kind of putting aside what a court would say about the speech or debate clause in that context, the idea that a fight over a subpoena to a sitting member of Congress would end up in court in some way, I think that's pretty likely.
It would certainly if the committee were to decide to enforce it, then certainly these issues will be raised by the member. So there actually is some law on this, not in the direct context of a contempt of a congressional subpoena, but in some analogous issues in the D.C. Circuit. So there is a D.C. Circuit opinion involving Congressman Feeney, who had an ethics proceeding that he was involved in, and then the Justice Department tried to subpoena from his lawyers some of the materials relating to that ethics proceeding, presumably because they wanted to look at potential criminal aspects of the matter that was the subject of the ethics proceeding. And the DC Circuit held that was protected by the speech or debate clause. But it's an interesting test that they have adopted in the DC Circuit based on prior cases. What they said was, if the underlying subpoena relates to matters in the legislative sphere, then speech or debate applies. But if it involves something outside the legislative sphere, then it would not apply. That test really is sort of incoherent and very difficult to apply, which is a point that was made by one of the judges on that panel, who happened to be Brett Kavanaugh. And he said, I agree with the majority. This is the test we've adopted in the DC Circuit, but frankly, I don't think it makes any sense. And at some point, we should revisit this and say that the speech or debate clause prohibits this under any circumstance. So this conceivably could be a difficult issue, and an issue that could go up all the way to the Supreme Court if it comes to that, if the committee ends up trying to enforce a subpoena against one of these members.
That test also seems particularly interesting because it touches on some of the issues that we're now seeing play out in the litigation of Thompson v. Trump, the lawsuit by Committee Chairman Benny Thompson against Trump, where part of the arguments that are being made involve Trump arguing that his speech on January 6th was part of his duties as president and therefore that he's protected from civil suit under Nixon v. Fitzgerald, and also Representative Mo Brooks arguing that the Justice Department should be representing him in this case, as he's also a defendant because his speech on January 6th was part of his congressional duties and not campaigning. You get to a similar kind of question of, to what extent is encouraging perhaps a riot or asking the president to call off a riot part of legislative duties, and to what extent is it just something completely different? Does that sound right to you?
Yes. It's analogous. The speech, there is a fair amount of law on what is covered by speech or debate, and it's narrower than the sort of all official duties that would be covered, that would be involved in a FTCA claim like Brooks is involved in. So I would think you'd probably have a hard time making the argument that calling the president to say that you should stop the riot, say something to call up these rioters, that's part of the legislative sphere as it's been understood. But on the other hand, the questions about the objections that McCarthy and others decided to make to that decision, that discussion, those issues would be speech or debate, I would think, or at least be a much stronger case for applying speech or debate. So that's why I said, depending on which of these topics you take from the letter to McCarthy, you will have a stronger or weaker case for arguing that speech or debate applies. But as I mentioned before, you could also take the position, which is what Kavanaugh suggested in his concurrence, that when a member is subpoenaed to testify in Congress, in his own house, that is part of the legislative. It's not the subject of the testimony that matters, but simply that they're acting in a congressional proceeding, and even though they happen to be a witness, that's still part of their legislative functions. I personally think that's probably wrong, but that is a position that Kavanaugh was leaning toward.
So what are the other legal objections that members could raise? Are there any more that are sort of specific to Congress investigating itself, or would they be left with the same objections that other witnesses have raised? And I think it would also probably be useful to just give a quick overview of what those other objections are, Mike.
So the general objections that have been made, I think, primarily are either objections to the way the committee was constituted, which is one of the primary objections that has been made by many of the witnesses. So objecting to the fact that the speaker did not appoint any of the Republican members that McCarthy had recommended, and arguing that that is a violation of the resolution that constituted the committee, and therefore the committee is ultra vires in anything that it does. That argument, which we can discuss further, but that I don't think would be any different for a member or non-member. It would be the same. The other set of objections relates to whether the committee has a legitimate legislative purpose in its subpoenas, and that can differ. That argument differs depending on specifically what information it's seeking. But the sort of broader argument is essentially that there's no real need for this committee to investigate January 6th for legislative purposes. It's really law enforcement. It's really attempt to score political points. And again, that sort of general objection is going to be the same for anybody. But I do think that a member potentially can try to make a specific objection with respect to subpoenas to a member, that the test for the determining whether there's a legitimate legislative purpose should be more stringent than it normally is. And that would be based on an extension of the Supreme Court's recent decision in the Mazars case in 2020.
So we can talk about the sort of more general objections to the structure and constitution of the committee, because Mike's right that those objections have come up from other witnesses, other folks who've been asked to provide information. But just to sort of underline something on that, I think, really perceptive point Mike just made about Mazars is that one of the things that I think some folks said in response to the Mazars decision is that it was about the president. It was about a certain type of information that might be sought about the president. But I think one of the things that Mike is underlining is that it kind of opened the door to kind of broader appeals to that decision, invoking some of that logic, whether a member would be successful in saying that Mazars means that a legislative purpose test for sitting members should be stricter than it should be for other witnesses. I don't know, but I think that it's one potential consequence of Mazars that perhaps we wouldn't have had reason to appreciate at the time.
Right. And Molly, I know you've thought a lot about the ways in which Mazars has kind of shaped how the committee is conducting its investigation.
Yeah, I mean, so I certainly, obviously, like we'll never know what they would be sort of emphasizing if Mazars hadn't been decided in the way it was. But I certainly think that the existence of Mazars and its logic and argument around legitimate legislative purposes has led the committee to kind of talk a lot more about what kind of legislation might be informed by the work that it is doing. We don't know, as of right now, what kinds of hearings the committee plans to have. We do know, again, based on public comments back in December, that they are planning several weeks of public hearings in this early part of 2022. One possibility is that some of these kind of legislative questions would be the sort of thing that they would explore, things like reforms to the Electoral Count Act, reforms to the Capitol Police, reforms to the intelligence community, that sort of thing. And so my opinion is that we've seen more of that rhetoric than we might have in a non-Mazars alternative universe. We'll see how it ultimately plays out in the next couple of months.
Yeah, I agree with that. I think that's a very true what Molly is saying, that the committee is clearly, when it communicates with witnesses, is making a point of always emphasizing the legislative purpose. And I think that would not have been something that would have been considered necessary or so important prior to Mazars. I think Mazars has very much influenced the way people look at these investigations. And perhaps, it's unfortunate and perhaps not the right way to look at it, because I think there are some other arguments that the committee could make and perhaps will eventually make if it gets to that point. But right now they are proceeding as if their investigation needs to be hooked to specific legislative outcomes, or at least potential legislative outcomes.
And one sort of irony of this, at least to me, is that there is other, I think, real substantive work going on in other congressional committees on some of these legislative questions that we don't want to kind of overshadow because the select committee is doing so much talking about its legislative purpose. So there was, for example, just this week, a report put out by the majority staff of the Committee on House Administration, which is the committee that would have jurisdiction over changes to the Electoral Count Act in the House. Their majority staff put out a report on potential reforms. On the whole other side of the Capitol, in the Senate, in particular, several Senate committees have, I think, been continuing to do real strong oversight work around what are potential additional reforms needed to the Capitol Police and to Capitol security. Some of those would require legislation. Some of them, including some that have already been adopted, would not. And so I think that this, we've sort of ended up with kind of like a two-track conversation here about legislation and what it means to kind of have a legislative purpose in this area. I do think it's probably worth talking about the other piece that Mike touched on, the other argument that witnesses and folks who have been asked to provide information have been making about the structure of the committee. So I'll just start by kind of summarizing this at a high level, and then Mike can jump in. And so we saw a pretty clear articulation of this argument actually in a court filing this week in the DC District Court from the named plaintiff is someone named Taylor Budowich, who is a former Trump spokesperson, who is actually seeking to force the Select Committee to return some of his bank records that it has already obtained from JP Morgan Chase. And in the kind of House response to this lawsuit, you see the Doug Letter, the House General Counsel, and a series of other attorneys kind of lay out their response to this argument that the committee has not been properly constituted. And so basically, the arguments that others have made are some of the things that Mike touched on before. So things like the resolution authorizing the committee specifies a certain number of members that it should have. It does not have that full number. The resolution requires consultation on the part of the speaker with the minority leader. It notably does not require, the language says consultation. It does not say, for example, that the minority leader would get to appoint members directly himself, that sort of thing. So there really is, there are a number of arguments that folks have made that say that the committee is not properly constituted. Mike can sort of get into some of the specifics, but I'll say just as a general matter, courts have historically given a lot of deference to Congress on its internal rules under the rulemaking clause that gives Congress the power to organize itself. And so I think my read is that generally the courts have tried to stay out of a lot of these cases because of the deference that they've given to Congress on these questions. But I'll let Mike come in and talk sort of more specifically.
Yes, so that's right. So there's actually two different lines of cases that are relevant here, or potentially relevant. There are cases that deal with the rulemaking clause where someone is trying to just generally complain about the rulemaking, some rule, congressional rule, or argue that it limits the power of Congress in some way. And in those cases, the courts have said, or the DC Circuit anyway, has said that where a rule is ambiguous, it would be improper for the court to interpret it, because then it would be essentially assuming the rulemaking function of Congress. On the other hand, in the context of contempt prosecutions, there have been instances where the courts will kind of strictly construe the rule in a way to ensure that witnesses are not sent to jail if the committee's power to ask the question is not clear, or the fact that the witness was required to answer at that time was not clear, or the lack of quorum. Those kinds of things are often strictly construed in a way to ensure that the defendant's liberties are not infringed upon. So it'd be interesting to see which of those lines of cases will control here. But my general sense is this is kind of a pretty long shot type of argument. Clearly, the speaker, and I don't think anyone can argue, the speaker was not required to appoint the members that McCarthy recommended. I think there's nothing in the resolution to suggest that, nor in precedent. I think I haven't actually seen the House's brief, but I imagine they cited some House precedents in which it was explained that the speaker has the discretion to disregard the minority's desired members on a committee if she chooses. So I think that probably is going to be a difficult case for the witnesses to make. The argument that even if the resolution didn't require the speaker to appoint the members that McCarthy asked for, she was required to appoint 13 members, because the resolution says the speaker shall appoint 13 members on this committee, and she only appointed 9. That is, at least has a little more textual basis to it, but I find it difficult to believe that the courts are going to say that, there has to be 13 members at all times. And in this case, what happened was she wanted to appoint Republican members, and after she refused to appoint 2 of the minority leader's recommendations, everyone else refused, right? That's my understanding. You'd have to basically argue she should have appointed Democrats to fill out the committee, and I don't think that really makes a lot of sense, or that you can argue that the witnesses were damaged by her failure to do that, even if you believe that she was somehow required to.
So let's talk a little about enforcement, which we've kind of been implicitly addressing in describing how a court might think about this. So far, I believe everything that has gone to an actual member of Congress so far has just been a request. The committee has not yet actually sent out any subpoenas. So let's say they do send out subpoenas, McCarthy, Jordan, Perry decline to comply. What happens then? What avenues are available? Mike and Molly, I'm interested in both of your thoughts here.
Well, I see there are sort of several different buckets. I guess the first, I think we've already touched on, which would be the legal enforcement that is going to court through either a contempt resolution that would go to the U.S. attorney for prosecution under Title II, violation of the Section 192 of Title II, the Congressional contempt statute. The other legal option would be to bring a civil suit, which was done on a number of occasions in the last Congress against Mr. McGahn, for example. The committee seems not to be as interested in pursuing civil suits as it was done in the last Congress, because I think, as Molly mentioned, it took so long to get these resolved. So what it has been doing is using the criminal contempt statute. And so that would be probably the most likely option if it goes the legal route. Another bucket would be internal disciplinary mechanisms. And I guess I can think of two primary ones. One would be for the committee to refer this to the ethics committee, right? And ask for the ethics committee to investigate and appoint an investigative subcommittee and look at the question of whether the member who refused to comply with the subpoena had violated their obligations under the House rules. Or alternatively, the committee could seek to just go directly to the House floor and ask for some sort of disciplinary measure against the member. I guess would be analogous to what the House has been doing with respect to people who have been violating the mask rules and the walking around the metal detectors and things like that, where the House has been fining them. So presumably the House could try to do that as well, or do that in this case as well, to fine members who refuse to comply with subpoenas. And then there's one other option, which I mention only because it's sort of interesting and is theoretically available, which would be to use the inherent contempt power, which would allow the sergeant at arms to go and arrest the member and hold them, detain them until they complied. I don't think, as a practical matter, that is going to be done, but it is theoretically available.
So I think one kind of important broader question, I mean, Mike has done a really good job of laying out kind of procedurally, mechanically, what the options are. I think a question that underlies all of that is, what would actually work? Would any of these enforcement avenues get a sitting member who is hypothetically issued a subpoena to cooperate in a way that he is choosing not to at this point? And so, we know, again, from the experience with Mr. McGahn in the last Congress, that certainly civil enforcement can be quite slow in compliance. We also know from the schedule of the criminal trial against Steve Bannon for his contempt citation that, in addition to criminal contempt not necessarily forcing an individual to comply with the subpoena in the way that civil enforcement might, that also takes a long time. So I think it sort of raises a bigger question about what an aggressive posture by the committee against sitting members is meant to do if it ultimately fails to actually get the information from the members that they're seeking. And so in some ways, I see this avenue of inquiry by the committee, again, which is a small piece, a really institutionally important piece, but a small piece of their overall investigation, as also an important signal from the committee about kind of how they are thinking about what happened before, on, and after January 6th, that they are demonstrating that even if they never get the information that they are seeking in this case, that they think that there's a there with some of their own colleagues around the run up to the day itself and the immediate aftermath of January 6th. So I think as we think about enforcement, the sort of symbolism in addition to the substance is important to think about.
I also wanted to ask about some different ways in which the committee has requested information about members. So the key one that I have in mind here is there was reporting, I think, some months ago that the committee had sent a preservation request to telecommunications companies for the phone records of a number of members of Congress who had some kind of affiliation with the Stop This Deal, including, I think, Jim Jordan, Mo Brooks, Lauren Boebert, and others. And McCarthy had responded to that news by saying that the companies would be violating federal law if they did so. So, Mike, I'm curious if you know what he was thinking of there, and also if you could zoom out a little bit and give us some context on whether there are specific legal issues raised or not raised by requesting information from a third party about members as opposed to directly from members themselves.
So let me start with the question of what McCarthy was saying. I think he was referring to what would happen if the phone companies turned over the records, not just preserving them. I could be wrong, but I believe what he was suggesting was that if they provide the information requested to Congress, they would be in violation of the Stored Communications Act. And there are provisions. The Stored Communications Act governs what these communication companies are allowed to provide, and it doesn't have any specific provisions regarding congressional requests or subpoenas. So you get into an issue of statutory interpretation that has not been resolved. There has been, in the past, there have been proposals to explicitly amend the statute to make it clear that Congress was able to use to get information from the phone companies, but that is not in the law at this time. So there is an issue. I think probably the best prediction is that Congress would be able to get non-substantive, that is not non-content, I guess that's the term, information from the company. So they wouldn't be able to get, say, emails, the substance of emails or phone conversations, but they would be able to get, you made a call to such and such number on such and such date, that they would be able to get that. But that is, remains a issue that will have to be litigated.
There's also been reporting about a subpoena to at least one House staffer. I believe her name is Maggie Mulvaney. She's a staffer for a Republican member of Congress who, before she began her work there, had been involved in planning the Stop the Steal rally. And if I'm remembering correctly, when that news first broke, there were sort of some statements from Republicans saying, that this was a really dangerous step, that it was a breach. I'm curious for both of your thoughts on whether trying to get information from staffers as opposed to members themselves raises similar questions as it does for members, or whether everything that we've discussed is really specific to the representatives themselves.
So I'll let Mike talk about any sort of legal questions, but I will say the point I made earlier about sort of concerns about precedent setting would certainly apply to staff as well. There are certainly other examples of congressional staff being investigated by congressional committees, but I think that, again, much like with the members, one possible consequence of the select committee taking an especially aggressive posture towards sitting members is if it took a similar posture towards staff, that you could see kind of that be picked up by a future Republican majority acting quite possibly in bad faith to do the same sort of thing towards staff in the future. But I'd be curious from Mike's perspective if there are any sort of ways we should think about it differently from the legal perspective.
Yeah, so the couple of issues that we've identified, the potential legal arguments that could be made by members that wouldn't apply to everybody, some of them I think would be different with respect to staffers. For example, arguing that the committee resolution needs to explicitly authorize the committee to subpoena staffers, I think would be a much more difficult argument to make, and less, probably would be less attractive to make that. With respect to the extension of Mazars, also, I think that probably would be, again, it's a long shot as to whether that could be made at all, but I think it would be much more difficult to make that argument with respect to staffers, that they should be treated sort of in a special constitutional manner. The speech or debate clause generally protects staffers in the same way as the members, as their alter egos. So if it came to prosecuting a staffer in court or suing them, those arguments could be made, even though theoretically the test is similar. And again, I don't know what specifically this staffer was being subpoenaed for. I guess it was for a role in organizing the rally. I think that would be, probably viewed as being outside the scope of speech or debate anyway. So I think probably if the committee decided that it wants to go after the staffer, but not after members, my guess is that would be viewed as somewhat of an act of, self-restraint on its part. And if they didn't go after the members, I don't know that the precedent would be such a big deal. It seems to me that the members have sort of signaled that they're prepared to go to the mat on this, and they're willing to take the consequences and pay back the committee in political damage if the committee decides. They may be bluffing, but they've sort of signaled that they're willing to, defy the committee's subpoenas and go to the court of public opinion and sort of take the maximum amount of the pound of flesh that they can get in political payback before they would, rather than complying. I don't know if a staffer is going to be in the same position, or that the Republicans will put the same amount of effort into trying to protect a staffer.
So I want to end by reflecting on the sort of bigger strategic picture here, and what this focus on members of Congress for at least part of the investigation tells us about how the committee is conceptualizing its investigation more broadly. Molly, I know you have thoughts on this. Can you talk a little bit about that?
Yeah, so this sort of just picks up on what I was talking about before, about the speed at which any effort to enforce a hypothetical subpoena would unfold. And so I think that given the time frame that we're looking at, which is basically the committee has, in all likelihood, the rest of this year to complete its work. We've heard different things from Chairman Thompson at different points about the exact kind of schedule they're planning on, but suffice to say, they don't have all the time in the world. I think one, and you've heard Thompson mention this, Thompson or other committee members mention this, that they do intend to produce some sort of written document that sets out a coherent narrative of their findings, that at some point they're going to get all the information they're going to get. And that may, depending again on how things unfold, that may not include the information that they have sought so far from sitting members. And their choice about how aggressively to pursue that information may come, again, depending on the time and resources involved, at the expense of pursuing other avenues quite aggressively. And I think Quinta and we have talked before about kind of what would constitute success for the Select Committee. And I think one thing I've always highlighted is the Select Committee getting information and making information public that only really it can get. And that might include some of this information from members. I don't know. But I think these questions that we're talking about both the sort of legal and substantive importance of this effort to get information from members are really important. But at the end of the day, they may not actually play a huge role in the ultimate account that the Select Committee produces.
Mike, any closing thoughts?
Well, I think, I tend to agree that the committee's on a very tight time frame, and probably if it decides to go after these members or any other witnesses, it's going to be doing that. It's not going to actually get anything that will be useful to it through doing that. It may vindicate its authority and perhaps be useful to some future committee that will be able to get information more easily as a result of the committee being forceful with witnesses. But probably it is not going to be able to get anything through legal enforcement in a time frame that works for it. I would just, if I could just, I alluded to the fact earlier about the way the committee was focused on on the legislative purpose and specific legislation that it will be, recommending or suggesting to other committees. I think in some sense that is unfortunate, because really there is a long history of Congress looking at its own internal affairs, both in the disciplinary context and also in the context of protecting its own privileges and ensuring the integrity of its own proceedings. That is a separate constitutional power that it has. And unfortunately, the way that Mazars unfolded, which did not involve that power, is constricting this very different factual scenario, one where Congress was actually, its own proceedings were disrupted by this mob, and really calls for perhaps a different type of investigation than one that is just focused on specific legislative fixes. So I hope that the committee will be able to at least give a broad picture of what happened and to put it in context for the benefit of the public and for Congress going forward.
Yeah, I'll just end by saying I completely agree with that comment from Mike. And also, I think that focusing, sort of having all of our focus on the Select Committee as the one organ of the United States Congress that is responding to January 6th really potentially does a disservice to other good work that is and could be happening in other parts of the institution. We don't want to let the committees of jurisdiction in some of these areas off the hook for things that they should be doing to respond to what happened. And so I think it's both that the Select Committee really does need to produce some sort of comprehensive assessment and investigation of what happened, and also that real legislative change needs other members and other actors within the House and Senate to push it forward.
All right, we'll end it there. Thank you both for coming on.
Thanks very much.
Thanks for having me.
The Lawfare podcast is produced in cooperation with the Brookings Institution. Please share the podcast and give us a review wherever you listen. And go to thelawfarestore.com for brand new pens, lanyards, and t-shirts. The podcast is produced by Jen Patja Howell, and our audio engineer this week was Hamza Shitu. Our music is performed by Sophia Yan. As always, thanks for listening.